All right, pause. We just opened this hearing with some classic courtroom humor about Staples, yes, Staples. Courtrooms may seem serious, but judges love to sneak in these light moments to keep things human. Anybody else picturing the judge with a secret stash of office supplies?
And you need something stapled? You didn't think I saw that?
The
only thing I'm going to say is she was not offended. I was not offended, but I will just say next time, bring your own staples.
Thank you, Your Honor.
Yeah, all right, you're welcome.
I thought there was pretty decent comedic value. That was the only thing.
You were so happy when she did the little thing, and then you just took off. I asked her, did he even say thank you? She said no.
I didn't want to.
That's okay. No, I didn't want to interrupt. Okay, all right, never mind. I am so done with you. Court calls the case. People versus William Katkey.
People.
Good afternoon, Your Honor. Tyler Velo, P number 75702 on behalf of William Katkey, standing to my right.
Your name, sir?
William Katkey.
Thank you.
Today's the date and time set for the probable cause conference, Your Honor. A discovery has been exchanged. We'd ask that this be set for an exam.
Okay. So discovery is complete and people have their witnesses available on the 25th.
Checking just now, Your Honor. Just have 1 second.
Now here's where it gets heavy. The defendant's case is being dismissed because he's been deemed permanently incompetent to stand trial after a traumatic brain injury. Legally, this means he cannot assist in his defense, and the court is not allowed to proceed with prosecution. Serious question: how do you balance justice for a victim with compassion for someone who literally cannot participate in their own trial?
Sir, can we possibly go 1 more week?
Counsel, have any objection to that?
No, Your Honor. Don't have an objection to that.
Okay. All right. Well, if you did, then let me know. All right. Preliminary examination in person, April 1st, 2025, 9 a.m. That is before Judge Washington. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls case, People versus Zachary Broder.
Andrew Shoulders appearing on behalf of People, Your Honor.
Good afternoon, Your Honor. That was on behalf of Zachary Broder, who's joining us by Zoom.
All right.
I think he's there.
Yes, he's there, and I just need somebody to unmute. If he could state his name, please.
Zach Brer.
Thank you.
Your Honor, the court had been in receipt approximately a month ago, or just slightly less than that, of a report from the Center for Forensic Psychiatry finding the defendant incompetent and not restorable.
Correct.
Just as a bit of a backstory, just so I can make an appropriate record, the facts of this case involved an accident where the defendant was traveling at a high rate of speed, car crashed, and the front passenger in that vehicle died. The defendant also suffered a number of brain injuries in that accident, and as a result, led to the report which the court is in receipt of. Because of the fact that the defendant, the reason for his lack of, or his incompetency is a brain injury, there's no reason to believe from the Center for Forensic Psychiatry standpoint, or in my review of both that report and the relevant case law, that I have any reasonable expectation that a petition would do any good as far as this case in the future. If there's any reason to believe that even over a long period of time, there could be some competency restored, that may be a route that we would go. That is not the case here, nor do I have any reason to believe that the defendant not being under a mental health petition is creating any danger for himself or others. So for those reasons, at this time, the people would be moving to dismiss this case without prejudice, and I'll have a knowledge process filed with the court.
Is there any objection to any of that?
There's not, Your Honor. That's all fair what Mr. Childers represents.
The case is dismissed then.
Thank you.
Thank you, Mr. Broder. Good luck to you, sir.
All right. Thank you.
Say thank you.
Thank you.
Court does call the case. People versus John Cahill.
Ready,
That's
Your
a lot of people.
Honor, Joe Simon on behalf of Mr. Cahill, who should be present on the Zoom. And Chuck, unmute his device and let him state his name, please.
Wait, we're not on.
There. How's that?
I'll notice how the judge carefully lists every possible consequence of this plea: jail time, fines, community service, even car immobilization. This is called a plea colloquy. The court does this to make sure the defendant fully understands what they're agreeing to. No one can come back later and say, wait, I didn't know.
Terrific. State your name, John.
My name is John Cahill.
All right, thank you.
And we have such day for a probable cause conference. At this time, the people have extended an offer to the defendant to plead to the currently charged count 2 in exchange for a dismissal of count 1. I understand that he's going to accept that offer and proceed with the plea today.
Got a correct statement.
It is, Your Honor. Mr. Cahill and I, as you can tell, I can't really meet him in my office, but we did review together the advice of rights form,
Right.
and he permitted us to sign it on his behalf, and he's ready to enter his plea.
All right. Does he have the physical ability to raise his right hand?
I don't know the answer to that question.
All right. All right, Mr. Cahill.
Yes, Your Honor.
All right. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
All right. Can you state your name again for the record, please, sir?
John Cahill.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of operating with a high BAC. Is that your understanding?
Yes, Your Honor.
All right. That's a misdemeanor, punishable by up to 180 days incarceration, a $200 to $700 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Yes, Your Honor.
All right. And understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty, Your Honor.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
All right. You went through an advice of rights form and gave Mr. Simon permission to sign your name to that. Is that correct?
Yes, Your Honor.
All right. Did you have any questions regarding any of those rights?
No, Your Honor, I do not.
All right. And in paragraph 5, those explain your trial rights. You understand that you're waiving those rights as well as all the rights that are contained on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
All right. Are you on probation or parole, sir?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you're guilty of this offense?
Yes, Your Honor.
October 4th, 2023, at East Michigan Avenue near Moon Road in Pittsfield Township, were you operating a motor vehicle?
Yes, Your Honor.
All right. Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes, Your Honor.
All right. Do you recall what you had and how much?
Ooh, this is a good moment. Defense just requested permission for the client to check in with probation virtually. This is becoming more common post 2020, but judges still have the final say. Remote appearances save time and resources, but can be controversial. Do you think probation should always require in-person meetings?
A couple cocktails, Your Honor.
Were you stopped by the police or was there an accident?
There was an accident, Your Honor.
Okay. And at the accident, did the police arrive?
Yes, Your Honor.
All right. And Were you taken to the hospital, sir?
Yes, Your Honor.
All right. And did you have your blood drawn?
I believe so, Your Honor.
All right.
Yeah, the people would allege a 0.175 blood alcohol content. I don't think that's in dispute.
It's not, we stipulate to that.
All right. Do you have any reason to dispute the blood test results in this case, sir?
No, Your Honor.
All right, very good. Based on that, counsel, has the court complied with the court rule, and would it be proper to accept this defendant?
People are satisfied.
Yes, Your Honor.
All right. Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at court. Well,
It's your matter, yes.
pardon?
It's your matter, yes.
Yeah. So pre-sentence investigation and order is ordered at 14A1 probation. Sentencing will be April 9th, 2025, 9 a.m. That's before me.
Thank you, Your Honor.
Your Honor, and thank you. Is there a way, would the court permit, if I can work it out with your probation department, if he could report by video? If I could.
Yes, I'm not going to have a problem with that. I thought maybe, but we don't have them up today, that we might have been able to put him into a breakout room right now. But yeah, if they, that's fine with the court.
Thank you.
Whatever way is satisfactory with Ms. Valera. All right. Bond will continue.
Thank you.
All righty. Thank you, Mr. Cahill.
Your Honor.
Thank you,
Yes.
While I admit to aspiratation and control, the staple in question resides in the court's file right now.
Oh, it does?
There's no permanent intention to deprive permanently.
So the staple is back to its rightful home. Good. Court does call the case. People versus Stephanie Serene, or Serene.
Right. Thanks.
Serene.
Your Honor, Joe Simon on behalf of Ms. Serene. Stephanie, state your name.
Stephanie Serene.
I have before me a plea form that indicates.
Did you catch that? The defendant's parents are literally sitting in the car waiting to drive to Florida, and the lawyer is negotiating travel permission in real time. This is a real reminder that courtroom decisions affect real life, right down to your family vacation plans.
1, 2 controlled substance, and that plea, I guess, is being taken under 7411.
That's correct.
There's also, and upon our successful plea to that charge, count 1 would be dismissed. There's also the agreement between the parties of no upfront jail. However, this is not my case. I cannot buy a judge prior to that, so the parties should be aware of that.
And I explained that to my client, and she signed it out, the sentencing judge waived.
All right, very good. May I have her sworn?
You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God. State your name.
Stephanie Serene.
All right, ma'am, it is this court's understanding you're going to plead guilty to the charge of use of a Schedule 1 or 2 controlled substance. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
All right. You understand also, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr
Yes,
in
Your
the
Honor.
1482 District Court.
Yes, Your Honor.
All right, understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of rights.
Yes, Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
Between the dates of February 23rd, 2023 and March 16, 2023, the location of 5301 East Huron River Drive, Superior Township, Washtenaw County, State of Michigan. Did you have a Schedule 1 or Schedule 2 controlled substance in your possession?
Yes.
All right. Did you have any authority to have either one of those in your possession?
No, Your Honor.
All right. And had you used them?
Yes, Your Honor.
All right. Counsel?
I do want to clarify one thing.
Yes.
My client is not on probation or parole to any other court. She's actually technically on probation with to Lara, correct?
All right. Have I complied with the court ruling? Would it be proper to accept?
The people are satisfied.
Yes, Your Honor.
All right.
I will get right there, right?
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be
Before Judge Barr.
April 15, 2025, 10 a.m. before Judge Barr.
Okay. Your Honor, we're going to work on maybe moving that date and ask the court if it would permit a travel request from April 9 to April 15th. My client's parents, who are actually sitting in the car out in the lot, have family travel to Florida, and they want their daughter to join them.
I kept shaking my head no, and he kept talking. He just wasn't paying attention. That's 2. That and the staple assignment. What are the dates of travel?
April 9 to April 15.
And you'll be returning on the 15th?
Mhm.
All right.
Yes.
I'll allow that, only subject to one caveat. If for whatever reason the date does not get moved in 14A2 for sentencing, then you cannot go, or you must come back on the 14th. You have to be at sentencing. Okay?
Thank
Very
you.
good.
Your Honor.
All right. Thank you.
Hey, race where things get tense. The defense is asking to lift a no-contact order so the defendant can see his girlfriend, but the judge isn't convinced. Even without a domestic violence charge, the court is erring on the side of caution. This is one of those gray areas where personal relationships collide with public safety. Whose side are you on?
Court does call the case, People versus Zehan Joe.
And on behalf of the people, Your Honor.
Your Honor, Joe Simon, on behalf of Mr. Joe, state your name, Zehan.
My name is Zehan Joe.
All right. I have before me a plea form. Indicates that the defendant would be pleading to the charge of disorderly jostling, the 90-day offense. Upon a successful plea to that charge, counts 1 and 2 would be dismissed. The parties agree to no upfront jail. Of course, I cannot bind the sentencing judge to that. I also don't have marked on this. This is a guilty plea.
It will be a guilty plea. I've been informed by another lawyer for the collateral matters that the factual basis is paramount, so it will be a guilty plea. And
Gotcha.
and you know, I maybe I should ask Ms. Zenda, the pleas to disorderly, I don't think that people care on the basis of the disorderly, whether it's jostling or another. Is it? Okay,
All right.
thank you.
Okay. I have him sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, Your Honor.
State your name.
Zehan Joe.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of disorderly person. Is that correct?
Yes, Your Honor.
That is a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. You understand that? You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court. You understand?
Yes, Your
that?
Honor.
All right. Now, understanding all of that, do you still wish to plead guilty
Yes, Your Honor.
to that charge? How do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form today?
Yes, Your Honor.
Any question regarding those rights?
No.
Look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Are you on probation or?
No. All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Your Honor, I don't know that the court said it, and I'm sorry if I missed it. The parties agreed to a sentence of no upfront jail, and my client knows that this court can't bind the remand judge to that.
Yeah, I did say that.
I'm so sorry.
That's okay. No, that's fine. Has anybody promised you anything other than this?
No,
Other
Your
than
Honor.
what's stated? Anybody threaten you or coerce you in any way?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
All right, and also because you believe that you're guilty?
Yes, Your Honor.
Because of what you've indicated, Mr. Simon, you may move on here.
On the November 15, 2024, in the city of Ann Arbor, at the location of Main and East William Street, were you present on a public sidewalk?
Yes, Your Honor.
At that time, were you loud and did you create a public disturbance in front of an apartment building?
Yes, Your Honor.
Counsel, with that, as I complied with the court rule, would it be proper to accept this defendant's plea?
People are satisfied.
Yes, Your Honor, and thank you.
Court will accept the defendant's plea guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
April 2nd at 9 a.m. before the hearing.
April 2nd, 2025, 9 a.m. before Judge Perry. Bless you. Fine, will continue.
Thank you, Your Honor.
Here, 8 times.
Wait for me right outside, please.
Court calls the case of the people versus Rick Artuso. Yeah, we can probably do this without him. No, I'm kidding. They're coming in. Here they come. You're good, sir. Come on up to the
Andrew Childers appearing on behalf of the people.
Good afternoon, Your Honor. May it please the Honorable Court, David Burgess on behalf of Mr. Arturo. Stay, am I right?
Your name, sir?
Rick Artuso?
Okay. Sorry, I'm sorry.
Oh, you're fine. And you're requesting an adjournment?
Yes, Your Honor. I just got the case. I need to speak to my client, and I was Mr. Childers about a possible resolution at this stage, Your Honor.
All right. April 3rd, will that work for you?
That's fine, Your Honor.
All right. Probable cause conference will be adjourned April 3rd, 2025, 9 a.m. or as your invite indicates. Bond will continue. All right. Thank you, sir.
Thank you, Your Honor.
Be right over. Court calls the case of the people versus Charles Carker.
Ready, Your Honor. And good afternoon again, Your Honor. May it please the Honorable Court, David Burgess on behalf of Charles Carker, who's standing to my right.
Your name, sir?
Charles Carker.
Thank you.
Discovery is complete. We're requesting an examiner.
People have their witnesses available the 25th? Preliminary examination will be set in person, March 25th, 2025, 9 a.m. before Judge Moore.
Thank you, Your Honor.
Bond continued. Thank you.
Thank you.
Court does call the case of the people versus Christopher Willis.
Andrew Childers appearing on behalf of the people.
Good afternoon, Your Honor. Edward Rivers on behalf of Christopher Willis. Christopher Willis.
You're requesting an adjournment.
That's correct, Your Honor. I'd like to address the bond conditions at the appropriate time.
All right. Probable cause conference will be adjourned March 27th, 2025, 9 a.m. As to bond.
Regarding bond in this case, there are 2 counts of resisting that are currently charged. And one of the bond conditions, there was an individual that was present during the event that occurred. And one of those individuals, there was a no contact that was put in place, a no go to. The person in question is his girlfriend that he shares children in common. And then since he was arraigned, he's been having to reside at a different location and have his mother and her mother assist with exchanges of the children just to get the kids back and forth. But they do reside together. They tend to stay together. There was no charge of domestic violence. And certainly the report can speak for itself and the prosecutor can have their opportunity to give a statement, but I'd like the no go-to provisions lifted. I like the no contact lifted.
Response.
Your Honor, just for backstory, the facts of this case involved the defendant was attempting to rent a U-Haul. He was basically got into a disagreement, argument with the person working at U-Haul over his ability to rent it. They contacted the police because of the way he was behaving. As the police arrived on scene, as they were attempting to make contact with the defendant, he was arguing with someone, a female who may or may not have been his girlfriend. I'm not sure about that. She was basically trying to calm him down, and based on what the police reported, he shoved her away, and that's when the police were like, we're gonna place you under arrest, and then he fought with the police officers. So that's the basis for why that bond condition was made in there. That individual is not a victim on this offense. There was no assault and battery or anything charged out of that conduct. That said,
But I mean, she would be a material witness.
She would be a witness, yes. And I think that based on those facts, while they certainly didn't lead to a separate charge, I would ask that that condition remain in effect at least for the time being.
If I just may add, Your Honor,
Go ahead.
I've been able to review the video. Everything was seen on body cam. That individuals here and present in the court today would be able to address the court if there's any concerns with contact.
I think what I'm going to do is I think I'm going to leave that condition in place. Maybe at this time. The Washtenaw address is the U-Haul place, is that right?
That's correct.
Because I have two places. And so let's see what they did. I mean, and I understand what you're saying, that there haven't been charges regarding a domestic. However, and maybe that's because of what was presumed to be her status, but theoretically, I guess, if the allegations of the people are true, there could be, at which then these conditions would go into place. Mm-hmm. And so I'm going to sort of take the broadest sense of things. And so I'm going to deny your request to change bond. That may change once the examination comes around and you are before Judge Moore, or at some point you can take another look at that. But given what I'm hearing today, I think the bond condition is appropriate given the circumstance. And so bond will continue motion.